Good morning. Welcome to the Criminal Justice Committee. Would the committee please come to order and the clerk take attendance?
Chair Hope.
Here.
Representatives Andrews.
Here.
Carter.
Here.
Breen. Young. Here. Arbit.
Here.
Sievendorf.
Here.
Cerniglu.
Here.
Filler.
Here.
Mueller.
Here.
Pazat.
Here.
Harris.
Here.
Bagol.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you. Representative Cerniglu moves to adopt the minutes from the June 18th meeting. Without objection, the minutes are adopted. And just so everyone knows, we have a lot of people who want to speak today. We want to keep it nice and orderly and make sure everyone's name ends up in the minutes. So please turn in a white card if you would like to address the committee. We'll now hear testimony on House Bills 4655, 4656, 4658, 4659, 4660, and 4661. And I would invite the bill sponsors to come up to the table. Rep. Young, if you want to. Representative Meerman, you got here just in time. We're taking testimony from bill sponsors, so please have a seat. You can go ahead whenever you're ready, Rep. Young.
Good morning, and thank you, colleagues, for allowing us to come before you this morning on this package of bills that's not new to the legislature. We've been working on this for a while, and so grateful to have this opportunity to discuss pretrial bail reform on this morning. I'll begin with my prepared remarks. The package of bills before you are the culmination of nearly 6 years of work to provide a common sense and narrow approach to pretrial reform in Michigan. It is also the culmination of the governor's Michigan Joint Task Force on jail and pretrial incarceration. The pretrial bail package offers a unique path forward for Michigan's pretrial system. It was designed to meet the specific needs of Michiganders from in-state experts. Introduced with bipartisan support, these bills will foster great consistency, equity, and justice in Michigan's pretrial system. Bail reform can help address the disproportionate impact that cash bail has on low-income individuals and people of color. Research shows that these groups are more likely to be detained due to an inability to pay bail, even when the offenses are minor. These reforms will improve the lives of many people struggling economically, not just the individual who is detained. It is important to remember that bail affects families and other loved ones, who are often the ones paying the bond and taking the accompanying financial loss. The bondsmen keep 10% of the bond amount. As many of you have heard, pretrial reform has been politicized over several months, and even beyond that. The comments are made, unfortunately, are meant to scare folks sometimes and are not supportive of this common sense package. This is a very Michigan-specific package. Michigan isn't like any other state in the nation. Judges may set bail in cases where an individual is charged with an assaultive crime, violent offenses, and domestic violence, sex-related offenses, or other serious misdemeanors, a DUI, or a felony that is punishable by imprisonment for 5 or more years. Judges may also set bail in cases where an individual is arrested and charged with a new offense involving harm to a person or property that is substantially similar to the offense for which they were awaiting trial, or if they abscond while on any form of pretrial release. Let me be clear. Let me say this again. Assaultive crimes are not eligible, and our judges know it. And the package is focused on the sort of charges that don't pose a danger to society and should be kept, and we should keep people out of jail with the opportunity to continue to take care of family, themselves, and to keep their jobs. And I'll just close with this. When I was first introduced to this bill package in my freshman year, it was our former colleague, Representative David LeGrand. And we talked about this, and the thing that resonated most with me was all things being equal, our records, everything being equal. If my partner to the right of me can post bail, he gets to go home. But if I can't, because I just simply can't afford it, then I get locked up. And then that starts this ripple effect. Because if I happen to be a mom and a single mom and I don't have anybody to take care of my kids, now I'm locked up because, I'm first in the city of Detroit. Sometimes you just can't afford that car insurance. So you drive dirty so you can still get your kids to school. Then you get pulled over for the broken tail light that you couldn't afford to fix. And so then the second time you get pulled over, now you didn't pay the first ticket, and now I'm locked up simply because I'm low income. I think that's a great travesty. I think we can do better in the state of Michigan and allow people to have an opportunity who aren't folks that we are concerned about our safety, have an opportunity to continue to live their lives while waiting their trial, their bond, their hearing. So with that, I say thank you for your time, Madam Chair, and if it's okay, we'll pass it on to my colleague.
That would be me. Good morning. Thank you, Madam Chair. I'll do my prepared remarks and then I'll go on just experience. So, pretrial reform for low-level offenses supports public safety and promotes a more just and effective criminal justice system. It allows resources to be focused on individuals who pose a real risk to society while offering alternatives that reduce costs, minimize unfair racial and economic disparities, and foster long-term community safety and economic stability. When communities see how that low-level offenses are being handled fairly and individuals are not jailed simply due to their inability to pay, it fosters stronger relationships between public and law enforcement, which is essentially for maintaining safety. Pretrial detention for low-level offenders clogs up the judicial and correctional systems, which can delay justice for more serious cases. Bail reform promotes a more efficient system that prioritizes risk for those who actually pose a risk to public safety. Real quick, so I spent 25 years at the Wayne County Sheriff's Department. A lot of it was in corrections and courts. The one thing that people don't understand is the reason for pretrial detention is to ensure that you show up for court. If you can't afford it, there's a ripple effect. I've watched people lose their jobs, their families, their homes because they could not afford that bail. Since then, we've come real far. We have tethers. We have alternatives to incarceration because, as everyone knows, trying to get police officers, correction officers, has been a hard task in the past 10 years. So, and I'll give one experience. I was in charge of the weekenders, which were normally, DUIs, first offenses. Due to overcrowding, we used to send them home for the weekend. No, there has to be a consequence to your action. So I came up with a program where they had to go around for the whole weekend and clean up county buildings. So it was successful. They had to pay. There has to be a punishment that fits the crime. There can't be a free thing, but the bottom line is it unclogged the system and freed up beds. So if we're thinking about this from a public safety form, it makes places safer. It creates that understanding that if you can afford to be out, you will be, and if you cannot, there's alternatives. There's tethers. Thank you, Madam Chair.
Thank you, Representative Grant.
Thank you, Chair Hope and members of the committee for holding a hearing on this package. This package will create a fairer pretrial process by improving court processes, strengthening due process rights, and improving current bail practices. It will accomplish this by doing three things. First, it will limit cash bail for nonviolent offenses, as my colleagues have spoken to. Second, it will expand pretrial services and support. As my colleague Representative Carter stated, cash bail was designed to encourage people to come back to court for their trial. By providing resources such as court reminders, transportation assistance, and social services, we can help people comply with court requirements without resorting to pretrial incarceration. And finally, this package promotes racial and economic equity. As my colleague Representative Young spoke to, it addresses the disproportionate impact current pretrial systems in Michigan have on communities of color and low-income residents. It will ensure that everyone is treated fairly under the law. Pretrial reform helps reduce the burden on courts by freeing up resources, allowing the justice system to focus on more serious crimes and ensuring timely access to justice for all individuals, regardless of their financial status. Currently, pretrial systems throughout much of this state have been disproportionately impacting certain communities. Statewide research shows that approximately 60% of pretrial detainees make up Michigan's jail population. For many of these detainees, a judge has already determined that they can be safely released. The only thing preventing their freedom, however, is the size of their bank account. This perpetuates a two-tier justice system, one for the wealthy and one for everyone else. It also overcrowds our state's facilities, creates a hefty tax burden for our residents, and drives racial and class disparities. Detaining individuals for low-level offenses can be expensive for taxpayers, as pre-trial detention is costly for local governments. Bail reform leads to savings that can be reinvested into other critical public services, including crime prevention and rehabilitation programs. With fewer people in jail for minor offenses, authorities can focus on detaining individuals who pose a genuine public safety threat, improving the overall effectiveness of the criminal justice system. This package ensures that people are not unfairly incarcerated because they cannot afford to pay bail, making the justice system more equitable for everyone. Instead of placing people behind bars for being unable to pay bail, the focus shifts to ensuring that those who need support, such as mental health for substance abuse issues, can get it before trial, reducing the likelihood of recidivism. And now I'll turn it over to Representative Meerman.
Thank you, Madam Chair, members of the committee. The 5th and 14th Amendment to the Constitution enshrine our right to due process and our judicial system that holds that all defendants are innocent until proven guilty. The pretrial fairness package before you today addresses the court services a defendant receives prior to their day in court. When a defendant is arraigned, they must return for their day in court, period. There can be no exceptions, and someone fleeing their court date must face penalty. Not every defendant is a flight risk, and not every defendant is a risk to their communities. For low-level offenses, pretrial reform will ensure offenders can remain productive members of the society by maintaining their employment and housing. Pretrial reform supports individual liberty by allowing people to remain free pending trial while preserving the presumption of innocence. It allows individuals to continue their lives without limiting their freedoms before conviction. Pretrial reform preserves due process and fairness in the justice system. Thank you, Madam Chair.
Thank you. I was hoping someone would bring up the Constitution. Thank you, Rep. Meerman, and thank you, bill sponsors. We do have a question for you. Oh, okay. Just gonna wait. Would you like to, Rep. Young, would you like to speak to the amendments that we have worked on with the prosecutors at all, or would you rather I leave that for the prosecutors? Okay, that's fine. Okay, thank you all. Next, we have Chief Judge William McConico of the 36th District Court.
Good morning, everyone. Madam Chair, all committee members, thank you for the opportunity to speak on this bill package. Again, my name is Bill McConico. I have the honor of being the Chief Judge of the 36th District Court. But before that, I was a member of this most august body, serving in the legislature from 2000 to 2006, and before that, serving as a staff member here. And I was thinking before coming up that I was sitting where your guys are sitting 22 years ago, where I had introduced a bill dealing with criminal justice reform. And it was a bill that was introduced at the beginning of the session, and it was brought up in lame duck. The Republican chair of the Criminal Justice Committee, Mike Kowal, called me and said, we're running your bill tomorrow. Do the best that you can. And I was like, thanks. And so we came here. It was opposed by the Sheriff's Department, the Prosecutors Association, and the Attorney General at the time, Jennifer Granholm, opposed the bills. But we worked this as a bipartisan manner to make sure that we ended mandatory minimums on low-level drug offenses, as well as ended the practice of lifetime probation. And on Christmas Day of 2002, Governor John Engler signed that the most sweeping criminal justice reform that we've had in 20 years in the state of Michigan at that time. And so I bring that story up to say that criminal justice reform is not a partisan issue. When we passed it in 2002, it was a Republican House, a Republican Senate, Republican Governor, Republican Secretary of State, Supreme Court. But we did what was right, and it protected the citizens, and it became legislation that other states across the country adopted based on what we did, because we did it the right way. And we're here again for criminal justice reform. We have implemented the most sweeping criminal justice reform dealing with bail reform in the city of Detroit than any place in the state of Michigan. We have not had the issues that you see in San Francisco or you see in New York because we have judicial discretion baked in to what we do. We've actually seen the exact opposite of what you've seen in other states and other cities. I'm going to get into the specifics of our bail reform, but I'm going to get to the outcomes. I stood at a press conference last December with the Wayne County Prosecutor's Office, the Wayne County Sheriff, the Chief of Police for the City of Detroit, the Mayor of the City of Detroit, the County Executive of Wayne County, and the Director of the Michigan Department of Corrections, and the Chief Judge of Third Circuit. And we talked about crime rates in the City of Detroit. We have the lowest rates of carjacking since the term carjacking existed. We have the lowest homicide rate in the city of Detroit we've had in 50 years. We've had all violent offenses are down. We've checked the stats this year, and they're lower than they were last year. And the reason why I bring this up is that we have reduced crime in the city of Detroit during a time of bail reform. And so when some will say that if you have more people out on tethers or more people out on personal bonds, that crime will go up. That's just not the facts. That's not what we're seeing. And we have more aggressive bail reform in the city of Detroit than what you're proposed in this legislation. And we're just not seeing it. What we have done is we have altered how we're doing pretrial monitoring. Before, people just had GPS tethers, so you can just be out and do whatever you want to do. No, we have restrictions. The use of house arrest has been used a lot more. Curfews have been used a lot more. And if you violate your tether restriction, your bond is revoked. And so a person knows that. But what we no longer have is a person that has as we call it in Detroit, the trifecta, driving with their license suspended, no registration and no insurance, sitting in jail for 2 to 3 weeks on a case that they would not receive a day of jail time. They would have a fine, but they would not receive any jail time. But they're receiving cash bond. They were receiving cash bonds previously. We no longer have people not knowing who's going to care for their children, who's going to make sure that their elderly parents are taken care of because they're sitting in the Wayne County Jail because they drove without insurance. We've ended that, and we came to the situation not the way I would like. We were sued. We were sued by the ACLU in 2019 concerning our bail practices. I became chief in 2020. I let the ACLU know that we're going to fight this lawsuit, but we're going to work together to make a reform. And so it was an adversarial process that we worked collectively, and we have really changed bail reform. On traffic matters, we are a cashless system. We've not seen recidivism go up. We've not seen the failure to show up to court go up. But what we've seen go up is justice. And we've seen a person not sit in custody because they do not have the money to post a bond. And two last things, and I'll stop. We have a bond redetermination hearing that we have in Detroit, which is we're the only district court in the state that does this. When a magistrate sets a cash bond, an unaffordable bond at the arraignment, and they give a cash bond that it's unaffordable, Within 48 hours, that defendant comes before me, and I make a decision on whether they should have an unaffordable bond. If I found that they are a danger to the community, they're a danger to the complaining witness and or a flight risk, that bond will continue. If I find there's a less restrictive manner, then that bond can be reduced. And we have not seen crime go up with people who have had their bonds reduced. And so what I see a lot of is people who have retail fraud cases, shoplifting. They are on $100 bonds. They can't get out. I had 3 defendants last week who were on a $100 10% bond. They couldn't afford $10. I have people who are in jail because they have a tether restriction. And the reason why they're in custody, they have a personal bond, but they're homeless and they have no place to tether to. And so we've come up with situations where we've worked with some shelters now that will accept people who are homeless and let them be tethered to the shelter, because we don't want a person in jail because they can't even get a tether. And so we are addressing these things, and in our bail reform, we are including higher felonies. And there was a case 2 weeks ago, and there was a very tragic situation of an Oakland County sheriff who was murdered in the city of Detroit. And there are 3 defendants that are charged currently. There may be others that will come at a later time. And the 3 defendants came in front of me for a bond hearing. And there was a press release that Sheriff Bouchard put out that was a very blistering rebuke of me, and it was a very personal attack. But I don't mind, because I understand the situation that the sheriff is in. One of his troops was murdered, and I understand, and I have empathy and sympathy for the family. But there were 3 defendants, and this is the reason for bond reform. One of the defendants, who was the principal, who was alleged to have shot the sheriff, I gave him a $1 million bond. The next defendant, who had a very high culpability in the crime, I gave him a $1 million bond. The third defendant, who was charged as an accessory after the fact, he did not get the same bond that the other 2, because his actions did not denote. If he was convicted that day, he would not be sentenced to the same thing that the other 2 gentlemen were. And I bring that story up because I want people, when people try to inflame emotions and say that we're making things unsafe, make sure the whole story is out. Because I'm sure you didn't know that the other 2 defendants received $1 million bonds, because that was not in the press release. And we take it very seriously. I live in the city of Detroit. I raised my family in the city of Detroit. I want Detroit to be a safe place. There's no one that's pro-criminal. There's no one that's I want lawlessness in the street. And we are doing what we can, and we are using judicial discretion to make sure we protect our citizens, yet have a fair system. And so I thank everyone in this committee for listening to me. I know this is tough. This is tough, and you guys do really hard work, and that's why the citizens sent you here. And I thought about that every day I was here, that we have to make tough decisions. And this is a tough decision, but it's really about fairness. Those who deserve to be incarcerated on a pretrial basis will still be incarcerated. Those who can go home and be on a tether or a less restricted basis will be there. And I want you to know, crime has not gone up, it has gone down in a great way in the city of Detroit since we've enacted bail reform 2 years ago. Thank you, Madam Chair.
Thank you, Judge. Questions? Representative Dievendorf?
Hello, sir.
Hello.
People around here are tired of me saying that I'm old, but I remember you working on this that long ago. So thank you for still being here.
Thank you.
Our justice system believes in innocent until proven guilty. In absence of this legislative change, are we running afoul of that?
What we have to make sure is that bail is not punishment. And if a person is out on bail, they haven't gotten away with a crime. That is what the system, that is what a jury or a bench trial would determine. And bail is for the safety of the community, but its primary concern is to make sure people come back to court. And when you hear people say a person has gotten away with something because they're out on bail, they haven't gotten away with anything because the case is ongoing. Bail is not for punishment. It is for the safety of the community and to ensure that that person returns to court. And we have, and when I first became a judge, I wanted to make sure, you know, if a person missed a court date, I gave them a cash bail, and I wanted to make sure they came back to court. But I wasn't thinking of what is the ramification of a traffic offense that I have a person sitting in custody for 21 days on a case where they would never sit in jail for a day. And so we don't want to punish because of economics or because of fear.
Representative Breen.
Thank you, Madam Chair. Thank you for bringing this forward. I have many feelings about this package. And I know that everybody's worked very, very hard and made a lot of changes in order to make this happen. And I thank you for addressing the issue with Deputy Reckling. I know that is a very sensitive issue. It's a horrible tragedy.
Yes.
And I was going to ask you about it, but you already addressed it. And thank you for providing that additional information. And I agree with my colleague, yes, people are innocent until proven guilty. People are concerned about their safety. And what you said is absolutely true. Crime has gone down. This is my question. We're talking about Michigan, and it sounds like what you're doing in Detroit is working. If what Detroit's doing is working, why isn't everybody else doing this? And also, I'd like to know, how many people is this affecting? Like, who right now is sitting in jail for a non-assaultive crime? Like, who's out there? Like, how many people are we talking about? And then my last question is, I am concerned about the requirement where you can come back every 60 days to upon a motion, because that's going to be a heavy burden on prosecutors. So those are my concerns. Anything you have to say, I'd appreciate it.
Well, the reason why we're doing it in the city of Detroit, honestly, is because we were sued. And a lot of times people make change either because of lawsuit or legislation. Criminal justice and bail reform was not on the agenda at our court, but we were pushed into it, and it was the right thing. And because it has worked in the city of Detroit, and, you know, honestly, if it can work in Detroit, it can work in your community, because you're not faced with the same things that we're faced with. And the reason why it's working in Detroit and is not working in some other areas in the country is because other legislators did not put in judicial discretion. Some people just have to let people out. A judge should look at that individual case. There was a case last week where I had on paper, it looked like it should have had a personal bond. But there were some factors that I could tell in that case that this person was intimidating the complaining witness, was going to try to make sure that person did not come to court. That is not a person that should be out. That is a person that, for the safety of the witnesses and the complaining witnesses, they should be incarcerated on a pretrial basis. And in this bill package and what we're doing, we allow judges to look at each individual case. Now, having cases come back for reviews, I think is a good thing. And because it can show that there may be different factors in the case. You learn more things about a case as while the case is going on. And just to have a second eye or third eye on a case, or if there's a case that is really having an extended delay. During our COVID time, we had people who were awaiting trials in Wayne County sitting in jail for 2 years, 18 months before they're getting pretrial hearings. And what if a person is innocent? You don't get 2 years left. You don't get 2 years back from being incarcerated. So that is why you take a second look, just to make sure that this case is proceeding on track, or is there another way of making sure we ensure appearance at court and to make sure there's safety. And I forgot the last question. I'm sorry. How many are still in jail? Okay, how many are still in jail? That is something that we can't necessarily quantify. However, we run stats every month with the ACLU, actually, to see how, with different types of cases, how many people are incarcerated for this type of scheduled offense. But we know that there are not people in Detroit that are incarcerated for driving offenses and low-level offenses anymore, because they are receiving personal bonds. If it is a high misdemeanor, a multiple drunk driver, a person, or a third offense, which is a felony, those are the type of folks that may have a cash bond, alcohol tether, and things to protect the community. But they are treated differently than someone driving without tags or proof of registration.
Thank you. Thank you, Judge McConico.
Thank you.
Thank you, Rep. Young. You're welcome to stay if you'd like at the table. We do have. Oh, I'm. Do you want? Was it for the judge? No, it's for Rep. Young. Okay, go ahead.
Thank you so much, Representative, for bringing this important package forward. I have a question about the H1 substitute, particularly the change for the burden of proof from clear and convincing to preponderance of the evidence. Can you walk me through that and the committee through that change and what the rationale is for it?
Yeah, so that was one of the things that went over a lot with our stakeholders. They will do a better job explaining it because I'm not a lawyer.
Okay.
But you'll get your answer for sure. But in order to get what we got, and we feel good about where we landed in terms of neutral from our prosecutors. You'll be able to hear a little bit more about that soon.
Okay, thanks, staff.
And we do have Prosecutor DJ Hilson from Muskegon County on Zoom next, and maybe he can shed some light on this important compromise.
Good morning. Can you guys hear me okay?
Yes, sir.
All right. Well, good morning, members of the Criminal Justice Committee, Madam Chair. It's a pleasure to unfortunately join you virtually, but join you nonetheless and talk just real briefly about our role in all this. And first and foremost, I have to give great thanks and credit to not only Representative Hope and the folks on the legislative side of things that were very kind in meeting with us on a number of occasions over the last few years, as well as the special interest groups as well, and really listening and understanding where we were coming from as an organization, in particular as a key stakeholder in the criminal justice system. So thank you for that. We do take a neutral position on this package, and that neutral position was based on those conversations and what I would classify as some good discussions, detailed discussions, and certainly a listing of our concerns. In particular, the removal of the 48-hour hearing requirement. As has been asked, the change from clear and convincing to preponderance of evidence, which, just to get ahead of the question, has been the standard up to this point when it comes to bail questions and bail hearings. And then ultimately the removal of the speedy trial bill that put a great burden on prosecution as it relates to dismissing cases with prejudice. And so based on all those discussions and changes, the Prosecuting Attorneys Association is taking a neutral position. Obviously, that's conditioned on those changes remaining with these bills. And as always, we are looking forward to continuing to have any further discussions that either stakeholders or legislators wish to have with our association on these packages.
Questions for Prosecutor Hilson? Thank you, sir. Thank you for working with bill sponsors and entertaining reasonable compromises. I appreciate that. And I'm sure we'll be talking to you again soon. Next, we have Claudine Constant, Director of the Beyond Jails Initiative with the Vera Institute of Justice, and Phil Mayer, Senior Staff Attorney with the ACLU. I'm going to ask them to come up together if they don't mind.
Good morning, everyone. My name is Claudine Constant, and I am the director of the Beyond Jails Initiative at the Vera Institute of Justice. Vera is a national criminal legal system research and policy organization that has worked on pretrial reform across the country for more than 60 years. Our experience has consistently been that well-crafted bail policies make communities safer, improve case outcomes, and reduce taxpayer spending all at the same time. As such, in coalition with legislators, advocates, and judges from across the state of Michigan, VERA supported the creation of House Bills 4655, 4656, 4658, 4659, 4660, and 4661, otherwise known as the Michigan Pretrial Fairness Bill Package, which is a bipartisan package that aims to create a uniform pretrial bail decision-making framework and also requires a consideration of pretrial release without money bail for low-level, non-assaultive, non-domestic violence, and non-sexual offenses. To be clear, the people that would be eligible for these reforms have yet to be convicted of a crime. By revisiting statewide bail practices through requiring pretrial release for low-level offenses and adding parameters around bail decision-making in cases where bail is necessary, lawmakers will take an important first step towards reducing jail populations across the state. I'm just going to briefly go over what each bill does in the package, and then I'll get to talking about the work we did to get to neutrality with the Prosecutors Association. So 4655 establishes a uniform pretrial decision-making framework and is a principal bill of the package. This frees up precious judicial resources by requiring pretrial release without money bail for low-level, non-assaultive, non-domestic violence, and non-sexual offenses, allowing judges and prosecutors to spend more time evaluating bond decisions for cases that do implicate public safety, and requiring that they document their reasoning on record. Again, to be clear, the people that would be eligible for this scenario have not been convicted of a crime. House Bill 4656 establishes due process protections for pretrial decisions, creating important due process rights that impose limitations on and opportunities to redress pretrial conditions of release. 4658 extends the uniform pretrial decision-making requirements to interim bond packages, which extends the uniform pretrial decision-making framework to people accused of non-serious misdemeanors or violations of local ordinances. 4659 and 4660 repeals the bail for traffic offenses or misdemeanors to ensure alignment with policies in 4655. And 4660 eliminates the need to issue a receipt for a driver's license surrendered as a pretrial condition because such surrender is no longer allowed under 4655. And finally, 4661 extends the uniform pretrial decision-making requirements to failure to pay child support for people who have failed to pay child support. Legislators painstakingly drafted and redrafted the Michigan Pretrial Fairness Bill Package over the course of several years, with an initial introduction in 2021, with the support of advocates and stakeholders from across the criminal legal system. The primary goal was to create a package that was narrowly tailored to carefully reduce the use of pretrial detention and simultaneously ensure the safety of the community, to encourage support, positive or neutral, from stakeholders across the state of Michigan. The coalition took feedback on the original package from a broad group of stakeholders, including the Prosecuting Attorneys Association of Michigan, the Michigan District Judges Association, the Michigan Judges Association, the State Court Administrative Office, the Michigan Coalition to End Domestic and Sexual Violence, the Michigan Sheriff's Association, other law enforcement entities and voices, and advocates from across the spectrum of the criminal legal system. Some important changes that we made to the package after hearing back from stakeholders include: in HB 4655, reducing the burden of proof from determining whether a person poses the required level of risk for money bail from clear and convincing, which is like the gold star standard, to the preponderance of evidence, which, as we heard from DJ Attorney Hilson, that's the standard across the country, so we would just be in alignment with it. In HB 4656, we removed the requirement for due process hearing when a person remains in custody for 48 hours after the first appearance package, which was a bill that created the right to speedy trial. And finally, we also made the difficult decision as a coalition to remove HB 4657, a bill which would have created a statewide pretrial services.
A person's ability to pay should not determine who is released from Michigan's jails. Vera, along with the members of the coalition, believe that this pretrial fairness package represents an opportunity for this session's lawmakers to correct the course of Michigan's bail practices. We urge you all to vote yes. Thank you.
Thank you. And we'll take your testimony now.
Thank you, Chair Hope and members of the committee for this opportunity to speak with you this morning. My name is Phil Mayer, and I'm a senior staff attorney at the ACLU of Michigan, where I litigated the lawsuit that my now friend, Chief Judge McConaughey, discussed a few minutes ago. I want to start by emphasizing one thing. Although we filed this lawsuit in Detroit, the problem of courts conducting unconstitutional pretrial bail hearings was at that time and remains a statewide issue. We could have, and probably still could, file similar lawsuits against most urban or rural courts throughout Michigan. The agreement we signed settling that lawsuit has resulted in an array of simple but hugely significant changes, many of them inspiring some of the provisions of the bill before the committee today. And they have made Detroit, as the Chief Judge testified, a fairer, more equitable, and a safer place. That is consistent with research throughout the country that has shown wherever bail reform occurs, it corresponds with no change or significant decreases in violent crime, just as we have seen a significant decrease in violent crime in Michigan in the 2.5 years since we signed this agreement. Michigan's current bail system doesn't make us safer. It imprisons low-income and middle-class people accused of low-level offenses, and studies have shown that that it increases recidivism rates and makes our communities less safe. I want to emphasize what pretrial cash bail does. It forces people to buy their way out of jail long before they are ever convicted of a crime, when they are innocent until proven guilty. Data shows that approximately half of Michigan's jail population at any time have not been convicted of a crime. I believe that was a question earlier. Half of Michigan's jail population is not convicted of a crime and is sitting behind pretrial bail. And that's according to the Governor's Pretrial Commission from 2019. My clients' experiences are typical of what happens throughout Michigan. My client, Devontae Ross, was a young man experiencing homelessness who spent over a week in jail because he could not afford to pay a $200 bail associated with a 5-year-old ticket for being in a park after dark. He missed a CPS hearing while he was in jail, lost custody of his children, and spent literally years fighting to get custody back. Another client, Timothy Lucas, was an elderly man whose only source of income was $800 per month in the form of a disability check. He suffered from epilepsy, asthma, and an enlarged heart. He spent over a week in jail where he missed his medications because he could not afford $350 of bail imposed in a misdemeanor case arising from a dispute in the boarding house where he lived. Neither of these men was ultimately sentenced to a single day of jail when their criminal matters were resolved weeks later. My clients have lost their jobs, missed school, medical, and social services appointments, and were unable to care for their children. Another client, a single mother accused of disorderly conduct, misdemeanor, had to spend her family's rent money on her $700 bail. As a result, she moved in with her children into a relative's already crowded home, and it was years before they acquired a stable residence again, and she's never really been able to repair the relationship with her sister. These results are not constitutional, but they are common. Passing the proposed pretrial fairness bills will ensure that our courts abide by the provisions of the United States Constitution when deciding how much and when to impose cash bail. The Equal Protection Clause of the Constitution prohibits discrimination against poor defendants charged with crimes, but that's exactly what happens when we use unaffordable bail. To illustrate, imagine two people arrested for screaming at each other in the midst of a city council meeting or some sort of public forum. Both of them are arrested and charged with disorderly conduct, but one of them is poor. It's their first offense, but the judge, as is common throughout this state outside of Detroit, imposes several $100s of bail. There's no difference between these defendants. But the wealthier defendant will make bail and be free to assist in their defense. The poor, otherwise identical defendant will remain incarcerated, awaiting trial, or more likely, the pressure to accept a plea bargain. This illustrates how our current pretrial system is not focused on public safety. It's just designed to reward people with means. And it almost goes without saying, except that it's so important to say it and say it repeatedly, that all of the practices I've described have a disproportionate impact on people of color and their families. In summary, The bills before you go a long way to remediate many of the problems I've just described, but most importantly, by making our communities safer while assuring that the constitutional rights of low-income Michiganders are being upheld. Thank you for your time and consideration.
Thank you. Thank you both. Who's your question for? Okay, we have a question for the ACLU.
I do. You mentioned that 1/2 of the jail population is there on pretrial. Do you have any information as to what those various charges are? Is there a breakdown as to category, as to what they're being held for? I do want to know how many people are being held for non-assaultive or non-violent crimes, or what is it that they're there for?
Yeah, unfortunately, the data that is publicly available doesn't really break it down by charge. But I can tell you what I know from talking to defense attorneys around the state, from being at bail hearings around the state, is that a significant number of those people are on minor crimes, the type of driving offenses that Chief Judge McConaughey discussed, disorderly conduct. When we filed our lawsuit, and again, I want to emphasize, Detroit wasn't even the worst place by a fair measure in the state when we did that. We had to go, all of the clients I described, we saw in like 2 days of watching court. So it's incredibly common to see these, few $100 bonds imposed on people charged with disorderly conduct, very minor offenses. So I don't have an exact number, but I can say it's a considerable one.
Do you have any information as to what type of burden this would cause on prosecutors in their offices if they have to return to court every 60 days in order to handle any motions?
Yeah, I appreciate that question, and I think it's indicative that that Pam is neutral on the bill, that it is not an oppressive burden. I was actually just speaking with the chief judge about that before coming up here in light of your question to him about that. It's a 60-day review on motion by a defendant, so a defendant who knows that they're not gonna get out because the conditions isn't necessarily even going to seek that. But most cases that are lasting longer than that will be coming back before their judge approximately every 60 days or so anyways, for a status conference or some kind of check-in with the court. And that's an opportunity where these hearings can happen. So the burden should really be relatively small. And when I spend a fair amount of time watching bail hearings around the state in Detroit, they are serious. Evidence is considered, but they're also not hours long. They're usually measured in 10 minutes, not hours. So holding these 60-day hearings should not be an oppressive burden.
Thank you.
Representative Carter.
Yes, thank you, Madam Chair. Real quick, thanks to Judge McConaughey for talking about having that discretion. But I think people need to understand that when you're in custody, the county or wherever you are is responsible for everything. So I'll give you an example. I used to be in charge of medical, and we had a young man who was in a bad car accident. He was paralyzed from the waist down, but he was a level 1 offender. We had to put 2 officers on him 24 hours a day, stretching resources. So I went to the judge and got an administrative jail release because his ability to reoffend was 0. But if you look at it on paper, you say this is not a person that needs to be out, but at what expense to the taxpayers and to the staff. So I think that this gives us some latitude to address those things. And looking at the paperwork, you can make those decisions. But a person should not stay in jail under being presumed innocent because they can't afford it.
Did you have a question in there? No, okay. I was listening really carefully. I wanted to make sure I didn't miss it. Thank you both for your testimony. Appreciate it. We do have to move on. We have a number of people yet who would like to testify. I'm going to go a little bit out of line here and ask that Judge Miller from the 3rd Circuit Court, who is on Zoom, with my apologies to the for the time delay here. Please go ahead when you're ready.
Good morning, Madam Chair, distinguished members of the committee, staff, and the other speakers here today. Thank you for the opportunity for me to present to this body regarding support for House Bills 4655 through 4661. I am here representing myself, having spent my career primarily as a judge in the Michigan court system and as a speaker for the Law Enforcement Action Partnership, better known as LEAP. I support this legislative package because it would improve public safety by reducing unnecessary incarceration and prioritizing the use of correctional resources. LEAP is a nonprofit group of police, prosecutors, judges, and other criminal justice professionals who speak from firsthand experience. Our mission is to make communities safer by focusing law enforcement resources on the greatest threats to public safety, promoting alternatives to arrest and incarceration, addressing the root causes of crime, and working toward healing police-community relations. In the past 40 years, the number of people in Michigan's jails has tripled. On any given day, there are more than 16,000 people in Michigan jails, many of whom have yet to be convicted, resulting in costly and overcrowded facilities. And the resource for that, you can click the link in the statement that you have from me if you have it in electronic format, but that is pursuant to the information from the Bureau of Justice Statistics, which is a part of the Department of Justice. As a judge in the Third Judicial Circuit Court of Michigan, I often see people held pretrial for low-level drug possession and other minor nonviolent offenses. Our county jails have had to dedicate critical resources to hold people who did not pose a significant threat to public safety, clogging up our justice system with low-level cases instead of focusing on more serious crimes. Reducing unnecessary pretrial incarceration is key to protecting the public. That may sound counterintuitive, but putting someone in jail creates an array of problems. First, when a person is being held in jail pending trial, he or she sits in a cell and detention center with people who have committed much more serious offenses, which exposes them both to violence and basically a school for criminals. Second, a person sitting in jail pending trial is likely to, as we've heard today from others testifying, lose his or her job, have his or her driver's license suspended, and lose his or her chance to re-enter any recovery services. These collateral consequences only further increase chances of recidivism by increasing rates of homelessness and decreasing rates of employment. As a result, research shows that people held in jail pending trial for 2 to 3 days are almost 40% more likely to commit new crimes than defendants held no more than 24 hours. One key reason for unnecessary pretrial detention is that individuals do not have the means to pay bail. And I just want to echo that from the witness from the ACLU and Chief Judge McConaughey. That is exactly what we see. Oftentimes, individuals charged with nonviolent offenses who pose little flight risk have to pay hundreds or thousands of dollars in order to be released on bail until they have had their day in court. More likely than not, these individuals live in poverty and cannot afford the dollar amount on the predetermined bond schedule that many of our courts use to decide bail amounts. Rather than basing the bail amount on the defendant's ability to pay, whether he or she poses a flight risk, his or her ties to the community, and whether he or she poses a threat of harm to the community. The predetermined bond schedules are based on the category of the crime. Even when judges do not use a predetermined bond schedule, the amounts and types of bonds for the same offenses vary wildly, and thus the attorneys and the community cannot be certain about what to expect in terms of the bond amount. I am excited to see Michigan considering legislation that would create a new pretrial decision-making framework, limit the use of cash bail for individuals who pose no risk to the community, and improve support systems for those released pretrial. By passing these bills, Michigan would drastically reduce the number of people held behind bars pretrial despite posing no threat to public safety. If passed, this bill package would also help to steer people onto a better path while they await their trial. When we return people to the community pending trial, we offer them the opportunity to reunite with family, go to work, and receive addiction and mental health services. House Bills 4655 through 4661 would allow people to show the court that they are stabilizing their life and choosing a positive path. According to research by the Federal Probation Journal, people released from jail pre-trial are less likely than those held pretrial to be convicted, to be sentenced to longer incarceration terms, and to commit new crimes in the future. This bail and pretrial reform bill package is very specific to the needs of Michiganders, as it was based on a comprehensive set of recommendations created by a bipartisan task force. While this plan is unique to Michigan, similar pretrial reforms across the country have successfully contributed to public safety. For example, Illinois and Brooklyn, New York, have already implemented bail reforms and seen crime decrease. New Jersey and Connecticut have made similar reforms, and violent crime has not increased. I stand behind this bail reform bill package because I believe responsibly reforming the bail system would decrease recidivism and allow our public safety system to focus on the most serious safety threats. Thank you very much for the opportunity to make a statement before this body today, and thank you for the hard work that you're putting into making the decisions. I stand ready for any questions that any of you may have.
Thank you, Judge Miller. Does anyone have questions for the judge?
Very well.
I don't see any questions. Thank you very much, and thank you for your patience in waiting.
No problem. Thank you very much.
I am going to go a little bit out of order here just to make sure that we get some opposition on the record here before we have to conclude. Jeff Clayton, the Executive Director of the American Bail Coalition, would you like to step forward? And just to let everyone know, I do have a number of cards up here. The clerk will record them. I'm not necessarily going to have time to read them all in, but, and any received by email as well. We have those. Go ahead when you're ready, sir.
Can you hear me now? Okay. Good morning. My name is Jeff Clayton. I'm Executive Director of the American Bail Coalition. Happy to be here today. Or as Keith Richards recently said, I'm happy to be anywhere. You know, we are proud corporate citizens of the state of Michigan, our members, and of course our trade association is actually domiciled in Michigan, so happy to be here today. What I would point out first to you is that Court Rule 6.106, which is the Michigan Court Rule on bail, which is largely being overruled in spots by this legislation, really is the gold standard. You know, one of my favorite sayings in the law is everybody hates judicial discretion until they lose, or everybody loves judicial discretion until they lose, and then they hate it. But really, what we're talking about, national best practices, is leaving bail and conditions of release all on a level playing field for judges to impose, and that is what the current law does. This legislation says judges are getting it wrong. They're leaving too many people in. We don't like that. We want to, by legislative fiat, overrule that. And we want to go to a mini trial, basically, where evidence has to be put on in a court hearing when we want to go beyond the standard conditions of non-monetary conditions, or we want to impose a monetary condition of release. So that's a major shift. What's being missed in this debate is the creation of the affordable bail, and that's on page 8, lines 16 through 17. That is an irresponsible move because states like New Jersey, states like Illinois have created a robust system of preventative detention, denying bail as an alternative. Here, that's missing. Michigan's a right to bail state. So in essence, this applies to all offenses, and it says that you get out. Former Representative David LeGrand had this language in his bill and disagreed with me on this point. And I hired a former public defender, 30 years of experience in Washington, D.C., who practiced under this language to draft a memo to persuade him that that was the case. And it is the case that everyone in Michigan, regardless of the crime, will get a bail on which they can afford and be released. That is what this language means. And what's missing is the Illinois, the New Jersey system of changing the Michigan Constitution to make it easier to go to preventative detention. So that's why this is a major problem. You can talk about New York bail reform and all the other problems. That is a major problem here. The detention net itself that's been set here, I would argue, is more expansive than the net that was rolled back in New York 3 different times. But the real problem here is that the charge lodged by the prosecutor does not equal risk. Okay, so even though it's a low-level charge, the judge is looking at a high-risk offender who today is charged with a low-level charge. That's what's going on here. And that's why this legislation is flawed, because high-risk people are going to be charged with low-risk crimes, and judges are going to be hamstrung in that situation. The financial ability to pay inquiry is way too limited, and it overrules Court Rule 6.106. For example, it doesn't take into account assets or income. It just says what somebody can personally post within 24 hours. And of course, the land-rich, cash-poor problem. Real estate moguls can't liquidate in 24 hours. Could take advantage of this bill because they can't get the cash to post the bail within 24 hours. So I think you've got to do something there that's going to basically render it to where nobody can afford bail. Finally, the theoretical availability of conditions as a basis for release is a problem. In other words, I could be released on house arrest, but it's not available, so I get out anyway. And that's at page 8, lines 17 through 18. That's hugely problematic because that means if I'm releasable on all kinds of non-monetary conditions, which, by the way, the state of Michigan is not going to fund because we're not going to run House Bill 4657 to create statewide pretrial. We're not going to do that, which means if I could theoretically be released, but it's not available, I get out anywhere for free. I think that's another problem. The prior judge just testified that bond schedule facilitate the orderly release of people in the state of Michigan. That goes away under this bill package. What does that mean? That means judges are going to have to set every bail in open court. That's a huge financial burden on the state of Michigan. That was proposed in Los Angeles, and certainly the folks down there had a heart attack given the volume of cases that judges would have to do. So that's another restriction I would argue on judicial discretion, and judicial discretion to impose a zero bail by schedule. That goes away. In other words, if we want to pre-schedule that somebody gets out for free, we can't do that either. We've got to see them in open court under this legislation. Finally, House Bill 4656, a similar version was vetoed by Governor Gavin Newsom in California because of the resource pressure that it would put on the state. Now, I understand that this version is optional, but I think anybody who complies over 60 days is going to file a motion, is going to put the burden on the prosecutor, and is going to make the prosecutor go in and prove it up. And so, you know, my thought on this, and the reason we didn't really get involved in this debate in California, is I think bails will go up. I think people will get higher bails as a result of this because judges know that the condition's going away, and if they don't trust that the prosecutor is going to come in and put on a good case to continue that in, say, a domestic violence or other case where they think it's really, really important to have a tether, they're going to impose a higher bail and try to keep them in jail. And so we see this as anti-defendant, even though it appears on its face as pro-defendant. So I think, you know, we've supported the prior package. We've been involved in the reforms in Michigan, and what we've learned is really that speedy trial, lack of speedy trial of those incarcerated is what's driving these jail costs. People staying over 30 days in jail in Michigan pretrial are causing 82% of all jail costs. They're high-risk people, and we're not moving the cases forward. That's the number one thing that we can do, I think, to fix the problem. And as to low-level cases, I think we've already worked on that, and our coalition, working with the ACLU of Colorado and other places around the country in the over 45 states I've worked, have come up with the problem of these low-level offenders that are spending too long in jail. We recognize that as a problem, but I would submit to you this is much, much more and needs a lot more work than where it sits right now. So thank you.
Representative Arbit? No? Okay. Thank you, sir.
Thank you.
Yeah, we do have a couple more folks who'd like to testify. So if anyone can kind of abridge their comments, that would be great. If you're not willing to do that, I'm here with the microphone button. Judge Frank from the Michigan District Judges Association. Welcome, sir.
Good morning, Madam Chair, Vice Chair Andrews, Vice Chair Filler, members of the committee. My name is A.T. Frank, and I am here on behalf of the Michigan District Judges Association. We are an association of over 200 judges that every day are on the front lines of bail decisions. Like Judge McConico, where you are now, I once sat. And so I can't say it's good to be back here, but I do enjoy seeing Judge McConico and you members, and to reacquaint with old friends. We are here today to oppose the bills that are before you. We believe it is the association's position, not because we disagree in concept, we do. We just believe that we deal every day with a complex set of facts in the people that come before us, and those are unknowns. And by putting this legislation in place, gives a very complicated situation that makes our jobs harder. It does not solve the complex problems, the unknowns that we face every day. It takes away our discretion. The point that I'd like to make, I guess, in what we hear, at least as I sat back to listen, was that the examples given are judges that are not following the law now. If you expect them to follow your law that you pass, these packages of bills, good luck. They won't. So for those very few outliers that are not following the court rule, the presumption that we give them a non-cash bail, that presumption is what we are to follow. Then we go to the least restrictive means in order to ensure compliance with conditions of bond or to ensure that they appear. If they don't appear, or if there's an issue of safety to the community or the victim, then we can impose greater restrictions. So there is a framework in place. It's not complicated, but it is a framework in place that allows us to address those complex unknowns that we have to face every day. A couple points as well. There is data issues that are of concern. We don't have one central warehouse that we can pull the exact data that we need. We have the judicial warehouse, but it is not information that compares apples to apples. We have jurisdictions in the 83 different counties that don't always report the same, jails that don't report the same. So we don't have the data that we need to make informed decisions, at least not the true data that helps you make the informed decisions. For example, if you look at pre-pandemic incarcerations, they were high levels. If you go to post-pandemic, we wanted to clear our jails out. We changed our mindset. We did other things. Then what came into account were the bipartisan reforms that this legislature and the previous legislatures made that helped with taking misdemeanors and putting them into civil infractions. That helped. We did, and we thank the legislature for what you did with driving while license suspended, getting rid of the financial burdens that helps people get their driver's licenses. You did that. That helped reduce the jail population. So what we would ask is that going forward, that you go with uniform data collection, that you do a swift appeals process. You took that out, but that is so important, even though they can do that, but by putting it in legislation, you highlight that, yes, you can have that immediate pretrial review. Meaningful pretrial services, you took that bill out. That is something that we knew. Not every county has a pretrial service office. We do, but not everyone focuses or works the same. But it does help us in making those decisions. And then reviewing the constitutional issues with regard to bail, surety, and those issues. That would be nice to review as well. So what we would ask is that there is a commitment to, and we are committed to to fairness and justice as we go forward. While we do oppose the current legislation, we urge that we continue working in collaboration with you and that you work with us as stakeholders. And then we request to gather the data, to re-examine the 1964 bail reform. This is what we're here from. It was a riddle then that is insoluble, and it remains insoluble. But it is not a complicated situation that needs to be put in place. Let us address the complex situations that come before each individual court. And with that, Madam Chair, members of the committee, I thank you for allowing me to be here today and to present on behalf of the Michigan District Judges Association.
Thank you, Judge. We do have a question for you from Representative Filler.
Thanks, Judge. Good to see you.
Good to see you.
Just from this side, there's 100+ years of law enforcement experience on my side right here with sheriffs and law enforcement, and I think their thought is they want to see you have discretion, and they think that you have the best read of a situation in a bail situation, and that these bills limit that and tie your hands. So I think that would be our take from this legislation and just from people who've sat on the ground floor, and I believe that's kind of what you're saying here.
It is. Thank you.
Thank you, Judge.
Thank you, Madam Chair.
We have Dan Fines from the Michigan Sheriff's Association. Fines. I'm sorry, it's been almost 2 years and I still get your name wrong. My apologies.
Madam Chair, Madam Chair and members of the committee, thank you for having me here today. By way of brief introduction, my name is Dan Fanas. I'm the Deputy Director for the Michigan Sheriff's Association. The Michigan Sheriff's Association represents the collective interests of Michigan's 83 elected sheriffs. By way of background, I've got nearly 43 years in law enforcement. I spent 25 years in the city of Westland, where I retired as its chief of police. And then I'm proud to say I went to the Wayne County Sheriff's Office for the next 15 years, serving as the undersheriff, the number 2 person, for 3 successive sheriffs. I then retired and went to the Michigan Sheriff's Association. So I think, based off my life's history, I think I'm in a good position to answer some true questions about the state of affairs that exist, for example, in Wayne County. Rep. Breen had asked a question about how many misdemeanor offenders, for example, are currently in the Wayne County Jail. There's 94 pretrial misdemeanors. That's it. When I first started in 2007, there was approximately 2,800 plus inmates in the jail. There's only less than 1,400 there now. In 2007, there was 50 people on tether. Today, there's about 950 people on tether. And at one point, we reached as high as 1,800 people on tether. We believe in alternative forms of incarceration. So I think I'm particularly situated to be able to answer some particular questions about these bills. On behalf of the MSA, we're here to oppose this bill reform package as a whole. It is our position these bills do not advance, I'm going to read from some prepared remarks, Madam Chair. It is our position these bills do not advance public safety, and they represent a path towards measures that have been implemented in other parts of the country and are now being rejected due to adverse outcomes. There are stories out of New York where this system of no cash bond has resulted in 3 people alone being arrested 300 times for the crime of shoplifting. These same type of laws have been just overturned in the state of California because retail theft has become so rampant. If I can have you remember anything that I say today, it is the up-to-date figures that were just printed out for me out of the 36th District Court, which represents the city of Detroit. Today, there are 390,023 active bench warrants out of 36th District Court. There's 5,600 non-serviced felony warrants, and there's 12,500 non-serviced misdemeanor warrants. The bills being advanced today will not do anything to increase public safety, nor to increase the likelihood of criminal defendants appearing in court. If cash bail has proven problematic, the no bail system will undoubtedly prove to be worse. I would like to highlight just a few of our concerns with the bills that are presented today. House Bill 4655. This bill essentially creates a presumption that most accused offenders will be released without bail. Even offenders with criminal history and records of noncompliance will only be subject to conditions that require them to show up in court and not commit any new crimes between now and their next court appearance. If they fail to appear, no warrant will be issued. Instead, the court will have up to 30 days to determine if the offender has actually absconded. This is only delaying justice. If the offender is accused for an offense for which bond is approved, the bond must be reduced to a personal recognizance bond if the offender does not violate the bond or commit a new offense within 60 days. The bond is likely to have been the one reason the individual appeared or complied with the conditions of their release. To eliminate the bond seems counterproductive. In addition, in those cases when an offender is required to pay a bond, it is predicated on their ability to pay and the amount of money they can come up with in 24 hours. Most offenders do not have ready access to cash. This may be a contributing factor as to why they are an offender. By not coming up with any funds, the court is required to release them on personal recognizance. Again, this seems counterproductive. Another point, the court can only consider the accused's ties to the community as a mitigating factor to preclude the imposition of release restrictions. But these same factors can't be used to conclude that the defendant may not appear in court as required. Again, this seems counterproductive. Last, the Michigan Sheriff's Association was heavily involved as far as 6 years ago in negotiations and discussions with then Representative David LeGrand. One of the things that we had advocated, and at the time LeGrand saw the merit in, was the use of a risk assessment tool. None of these bills involve the inclusion of a risk assessment tool. This very same legislature has passed juvenile justice reform that involves the inclusion of those tools, and we believe they're valid and they should be included. House Bill 4685 deals with the use of tether, and I'm very pleased to see that Representative Carter recognized the value of tether. I too believe that they have great value. The problem, however, is this bill eliminates the possibility of putting offenders on tether for a number of property crimes, including retail theft and auto theft. They are limited for use in only domestic violence, assaultive crimes, and sex offenses. These have proven to be a valuable way of ensuring compliance with release terms, and it doesn't make sense to eliminate their use in this case. Last 4658 interim bond. The past legislature made changes to when officers may arrest individuals for misdemeanor offenses, and we were part of that process and we agreed with it. It also recognized that there are certain situations which offenders should be arrested and brought before a magistrate. Through negotiations, we established that individuals could be held up until 3 p.m. the following day for the purposes of their being fingerprinted and brought before court. This bill limits to the maximum period of time a person can be held for 3 hours. This may not even be enough for their prints to clear the process in order for us to establish a positive identification and establish whether or not the individual is actually wanted. If it is after hours, this will not even provide the police with the ability to bring the accused before a judge or magistrate to have the facts reviewed. I could go into more detail, but I know my time is limited. We are willing to answer any questions or discuss our concerns with this or other bills as members would desire. Thank you very much for your consideration and your time, Madam Chair.
Thank you. We do not have time for questions, unfortunately, and we're not going to take a vote today anyway, so I appreciate your testimony. And we have no absent members. Seeing no other business, we stand adjourned.
Thanks, Chair.